Welcome to the program. My name is Marty Schenkman, and I'm joined by a great group of colleagues, Professor Mitchell Gans, Jonathan Blattmacher, and Bob Keebler. Bob pulled the short straw and had to wear a tie and jacket. Sorry, Bob. Maybe next time you'll get the longer straw. And we're talking about a really important topic. The Supreme Court just issued an opinion in the Connelly case about buy-sell agreements, valuations, and a really significant impact on a number of closely held businesses. Just by way of 15 seconds, a quick background. In addition to Connelly, our closely held business clients have to deal with the FTC's new rule banning non-competes. They have to struggle with the insanity, it's probably a polite term, of the Corporate Transparency Act. And oh, by the way, the exemption's going down by half at the end of next year. And with the step transaction doctrine, people need to take steps now. So our closely held business clients really have a full plate. But we're going to just focus on Connelly today. Before we get started, we have two sponsors. Jonathan, did you want to make a comment about ILS?
Yeah, I mean, I'm one of the founders of Interactive Legal Systems, and my partner on that is Mike Graham, a great practitioner from Dallas. Our CEO is Vanessa Canega, whom I had the privilege of working with at Milbank for many years. And our mission is to provide great content for people and forums that really make your practice much more streamlined and much more profitable.
As a quick plug, I've been using ILS for years. I don't understand how to practice without document generation software. It literally changes the dynamic of what's done. And just my 2 cents, 2025 could be an absolutely crazy year. It could be as busy and pressured as 2012 was for all estate planners. So that's a transition, if you have not undertaken document generation software, that you want to do sooner rather than later. You don't want to have to make that transition during the pressures of the 2025 planning, and that's starting already. And the other thing is that with drafting software like ILS, there's so many more options of what you can do to tailor planning than what I've seen most firms have in their forms. So I certainly recommend it. And I'm not paid to do a promo for them, but it's great stuff. And when you're naming all the trustees for these slats and DApps and hybrid DApps and spats that you're creating, Matt, do you know any good trust companies people should talk to?
Well, fortunately, the industry has a number of really good providers, one of which is Peak Trust Company. Unfortunately, Andre, who you see pictured here, couldn't join us today. His wife is having a medical procedure and he's by her side. So while you don't get somebody as good looking as Andre, you get me. Really want to appreciate and welcome everybody to this webinar, and thank you for attending. The Supreme Court ruling in the Connelly case really does require some significant alterations to planning, and this is an important topic. So I'm Matt Blattmacher, current president and CEO of Peak Trust Company. We're honored to be able to sponsor this presentation, especially with such a distinguished panel. And if you don't know about Peak Trust Company, we offer trust administration to sophisticated estate planners, offering a full range of trustee services. We serve families and their trusted advisors with flexible and customized services, including just administrative only services. So have any questions, feel free to reach out to our team, see some contact information there. Andre is a great person to reach out to, very warm and helpful. And again, thank you for attending.
Thanks, Matt. So to lead us off, Professor Gans, I don't know if I could say the floor because it's a webinar, but the webinar is yours.
I take the floor. Thank you, Marty. It's a pleasure to be with you all today. Let me try and set up this Connelly case pretty quickly. The facts are really very straightforward. Many of you probably are already familiar with the facts, so let me just try and get them on the table quickly. We have two brothers, and they have a buy-sell agreement. And under their agreement, the surviving brother had an option to purchase the stock from the decedent's estate, from the decedent brother's estate. If the option was not exercised, which was the case here, the surviving brother did not exercise the option. If the option was not exercised, then the corporation had an obligation, a binding obligation to redeem the shares. So essentially, I think for our purposes, it's probably helpful to think about this as a straight redemption agreement, right? I think that's probably distills the facts in a way that makes it a little clearer, a little simpler. Okay, the other thing that's important here, next fact, is that the corporation took out a life insurance policy on the life of this person who had died to help fund the buy-sell, the redemption agreement. When the brother died, when the decedent died, the corporation, excuse me, as I've already indicated, the surviving brother did not exercise the option, springing the obligation of the corporation to redeem the decedent stock. Everybody agreed, there was no dispute, that the insurance proceeds had to be taken into account in determining the gross estate. Okay, so let me just take you through that for a moment, and that was not in dispute, so not a real issue, but just to give you a sense of this, the regulations under 2042-1 kick you over to 2031-2. And if you look at 2031-2, it says that life insurance in a situation like this has to be considered an additional non-operating asset. So it has to go into the valuation calculus, if you will, according to the regulation, as another or additional non-operating asset. I think the interesting thing here, the issue here, let me do it this way. The issue here is, what are we going to do with this life insurance? The regulation clearly provides that it has to be included in the calculation. But wait a minute, what about the fact that the corporation has an obligation to use the proceeds to redeem the stock? What do we do with that? What do we do with that obligation? And you may know there was an earlier case in the 11th Circuit called Blount, where the court said, yeah, that's an important point. We need to take that obligation into account. We need to reduce what's in the gross estate or offset what's in the gross estate because of that obligation. It's kind of like a liability, is what the 11th Circuit was saying. All right. Now, I think we all can agree quickly, right, that if you are valuing a decedent's interest in an entity and the entity has a liability to a creditor, right, that's going to reduce NAV, net asset value, and clearly has to reduce or have a suppressing impact on the value of the decedent's stock or the decedent's interest in the entity, right? Because you owe the money to the creditor, it reduces what's being transferred, if you will. So can we view this obligation to redeem, the corporation's obligation to redeem, in a similar way? Can we say this is kind of like a liability to a creditor and therefore needs to reduce the NAV, if you will, or to in some way suppress value? Can it be used as an offset? Now, I think, by the way, let me just give you my quick sense here of what's going on. I think that these arguments, which emanate, I suppose, from the Blount case in the 11th Circuit, I think these arguments are really designed to undo the effect of the regulation, right? The regulation says you've got to include the insurance proceeds as a non-operating asset, as I've already said, 2031-2 says that, right? And now this argument in effect says, well, look, it's true the insurance proceeds are coming into the entity and the decedent had an interest in the entity and this should be viewed as a non-operating asset on the one hand, but on the other hand, since these proceeds are coming in and then immediately going out to redeem the shares, shouldn't we somehow treat that as a liability? And if you go along with that theory, what you're really doing, I think, is kind of undercutting or undermining the regulation. And I think these arguments that come from Blount essentially seek, in my view, and the way at least I conceptualize it, to negate the effect of the regulation. In any event, that's the question in the case. The 8th Circuit, in the Connelly case, disagrees with the 11th Circuit, and now we're before the Supreme Court, and the question is, should we essentially treat the obligation to redeem as if it were a corporate liability, and therefore create some kind of an offset, reduce the amount of the inclusion of these insurance proceeds in the valuation of the decedent's interest in the entity. The court, as you probably all know by now, the Supreme Court rejects the estate's argument and says there is no, you cannot in this case take an offset for this liability, this obligation to redeem the decedent shares. That's not something that should be taken as an offset. And so in effect, the court is distinguishing this kind of an obligation from a standard corporate liability, which of course would be taken into account in determining the NAV. I want to mention briefly at this point, in note 2, in footnote 2, which may become an important footnote as further things develop, the court says we're not saying never. It says we're not saying that there may, that there can't be a case out there where maybe some kind of a discount or offset is permitted. So, and they give an example of a case where assets have to be sold, operating assets perhaps have to be sold in order to raise the money to effectuate the redemption, and that will of course constrain the future earning capacity of the entity. Okay, so they leave that open. So as I see it, as I recap all of this in my mind, I think of this as the court creating a kind of a general rule, that as a general rule, there is no offset or reduction for the corporation's obligation to redeem, but there's an exception in footnote 2, and the exact contours of that exception and when it may apply, obviously will have to be developed in future cases. So that's where we are. Now, let me just give you my sense of things here. It seems to me from an economic perspective, which the court was principally focused on, right? From an economic perspective, an offset is not really, I think, defensible. I mean, I agree with the court, bottom line. I agree with the court. I don't think an offset is economically defensible. And here's why. Here's something the court did not say, but maybe it's implicit in what the court says. But I think here's how I see it. It's the obligation to redeem is fundamentally different from a corporate liability, right? It's because with respect to an obligation to redeem, the corporation is getting something in the exchange, right? It's got an obligation, but it's acquiring something in the process. What's it acquiring? It's acquiring the shares. I mean, think about this, for example. Let's say you were valuing a corporation, right? And you found out that the corporation is in contract to buy a big asset, okay? And so they have this essential liability, right? They're going to have to lay out, the corporation's going to have to spend, I don't know, X millions of dollars on this property. And you say, well, is that a liability that we need to take into account and therefore reduce the NAV? And you'd say no, right? As long as the asset coming in on the purchase has a value equal to what's going out, to what you're paying for it, it's not in any way depressing the NAV, right? And so, and I think that's a fundamental difference here that's really critical, that when you have a liability, you've already incurred this liability. Yes, absolutely. If I'm a buyer of the stock in this entity, I want to look at the balance sheet. I want to see that there's a liability. It certainly is a negative effect on stockholders' equity. It certainly has a negative effect on NAV. And as a hypothetical purchaser, which is our standard for valuing things for estate and gift tax purposes, as a hypothetical purchaser, I clearly take that liability into account. But again, to go back to my hypothetical, let's use the word hypothetical here. I didn't mean as a pun, but if you go back to my case that I've posited, where the corporation's buying an asset, so they have an obligation, but they're getting something incoming in return, that's very different. And that's how I think this case shakes out. I think that's the bottom line for me on this case. Now think about this, just to lock this up.
Mitchell, isn't it true that when you take a look at section 2053, where you're allowed to take into account obligations of an entity for estate tax purposes, they say it's only to the extent that the obligation was incurred for full and adequate consideration in money or money's worth. And
Absolutely.
and that's a fundamental thing, and we don't have that here. I mean, it's just the shareholders got together and said, well, we'll have to be redeemed. I don't know whether Marty can bring it up, but I think we may have an example of that further on, Marty, on it. But Mitchell, continue.
Okay, thanks, Jonathan. I agree with you. We have that concept in the estate and gift tax law, throughout. I mean, I think you're referring to 2053 C1A, and it says if the claim against the estate is founded on a contract, right? It's only deductible. The claim is only deductible under 2053 if it was founded upon adequate consideration, and that makes sense. I mean, if I promise my daughter that if she stops smoking, I'm going to give her $1 million, and she then stops smoking and she sues my estate for the $1 million, 2053 C1A, as you're saying, Jonathan, precludes my estate from taking that 2053 deduction. And so that's a theme that we see throughout the estate and gift tax law, and I take your analogy. So let me just continue with what I was saying about the economics. So I wanted to just make one more point about it to wrap up my thinking that I think the court's got it right economically. Think for a second about an investment in a company. I'm just pulling one out of my hat here, Apple. Okay, if you take a look at Apple stock, I have never seen anybody say in appraising Apple or thinking about it as an investment, I have never seen anybody say or write that, we ought to take into account in a negative way. We ought to reduce our target, or we ought to reduce our prospects for Apple, because after all, it just undertook a redemption obligation, a buyback, right? No one does that. In fact, quite the contrary. A lot of people say, you know what, the buyback is actually going to increase the value of the other shares, of the shares that are not repurchased. And so it seems to me that makes it open and shut. I mean, there's a perfect example from the marketplace that we all know and we all are familiar with, and I think it blasts out of the water any idea that somehow this should be treated like a liability that suppresses the NAV or somehow warrants a discount. So that's pretty much it, but I want to go on a little bit if I may. I want to point out, and here I'm getting into the weeds a little bit of this case, but that's what law professors do, so let me give it a shot, okay? So I think the court is somewhat internally inconsistent in the way it reasons itself through to this conclusion, okay? On the one hand, the court says that a hypothetical purchase, and that, I think this is interesting. I kind of trying to be cute about the weeds and being an academic and so forth, but I think this is interesting because it may inform us going forward about how to apply the hypothetical purchaser test. I have found over the years, especially when I talk to students about the hypothetical purchaser test, that it can be a bit difficult, or a bit difficult to get your arms around. And so I want to say here that I think the court was internally inconsistent on this question and may have muddied things up a little bit. Okay, so let me give you my shot at this, if I may. So on the one hand, the court says that when you're thinking about the hypothetical purchaser of these shares, you have to take into account the redemption. In other words, if I'm a hypothetical purchaser of the decedent shares, I am going to take into account, the court says, the fact that when I buy these shares in this hypothetical purchase, I am acquiring, in addition to the shares, the right to be bought out at this price under the agreement. So in other words, in assessing how much a hypothetical purchaser would pay for these shares, we need to take into account the existence of the redemption. And because the redemption obligation on the part of the corporation is an enhancement, the court says, to the value of these shares, and a hypothetical purchaser would take that redemption into account. So that's on the one hand. Remember I said internally inconsistent. On the other hand, the court then, almost in the next paragraph, makes this remarkably inconsistent statement. It goes on to say that we cannot take into account the obligation of the corporation to redeem as a kind of a suppressant or a liability or to create an offset, we just discussed. We're not going to do that because the redemption is going to occur post-death. And we have to take into account only what's true at the moment of death, at the time of death. And so you see how they're sending mixed signals. They're internally inconsistent. On the one hand, in evaluating what a hypothetical purchaser would pay for the decedent shares, we take into account the existence of this redemption obligation. But when we then turn to the corporation and we look at whether we can take an offset or reduce the value of the NAV or whatever, there we can't take into account the redemption because it's going to occur some moment after death. That seems crazy to me. And by the way, this latter point that we can't take into account what's going to happen after death seems even more strange to me in this sense, right? Typically, the way we think about these things, the way we think about valuation, is we say on the valuation date, we're going to value this stock and we're going to take into account what's reasonably foreseeable. So the fact that something may occur after the date of death, after the valuation date, doesn't mean we ignore it. Quite the contrary, we say, hey, look, if this is reasonably foreseeable as of the moment of death, then it has to be taken into account in the valuation calculus. The one example I came up with immediately when I appreciated this was key person discount. Somebody who's running the company is a key person, they die, and the law is quite clear that you can take a discount for the fact that this person will no longer be here running the company. They'll be absent, and that's going to suppress value. A hypothetical purchaser buying this business would say, hey, with the decedent gone, he or she was a key person, we're going to pay less for this than if we were getting the enterprise with the key person in operation. And there you notice that's all something that's happening post-death. And so it seems to me the courts just got it completely wrong. They muddied this up. And in fairness to the court, look, the Supreme Court justices, they're not tax lawyers, right? Nor certainly not estate tax lawyers. They're kind of generalists. I mean, one day they're doing criminal law, the next day they're doing God knows what, and then the next day they're doing this. And so for them to muddy this up is not surprising, but I wonder if it's going to create any wrinkles for us going forward. I think, some court somewhere down the road, we're going to have to get this cleaned up, but I do think they did a bad job with it. Ultimately, I'm going to try to wrap up in a few minutes here. Ultimately, I think the court, as I've indicated, reached the right decision. I think the Apple hypo is a great hypo, and as I said before, I think it blows any concept of discount here out of the water. Just doesn't make any sense. I think as I said before, I think this argument was designed to undercut or negate the provision in the regs in 2031-2 that the life insurance proceeds have to be included as a non-operating asset. This was designed kind of a backdoor way to undercut that or negate that, and it gets rejected. Final thought before I wrap up is I wanted to talk for a couple of minutes about 2703. Okay, so 2703, you're probably all familiar with 2703. It came in, I think, was it 1990? It's a valuation rule, and essentially what it says is that options and agreements and other restrictions on property should be disregarded as a general rule. Okay, so any agreement, restriction, or option under 2703A, they're disregarded in valuing the property as a general rule. Then you slip down to the safe harbor in 2703B, and if you satisfy the contours or the requirements of subsection B in 2703, now you're okay. Now you're out of, it's an exception. Now the general rule in 2703A that we disregard the restriction or the option is now pushed off the table. We now give credence. We now look at that restriction or option or agreement, and it can be binding for valuation purposes, or certainly relevant for valuation purposes. So in this case, what's interesting is that the lower courts had held that the agreement did not satisfy the requirements of 2703B, did not satisfy the requirements of the safe harbor. And so therefore, this case falls under the general rule in 2703A, which means that the agreement had to be disregarded for valuation purposes, for estate tax purposes. What's interesting to me about that is that in the Supreme Court, that was not at issue. The estate did not argue that 2703 was improperly invoked in the lower courts. And so you take that as a given. So I had written an article before the case came down arguing, well, if you ignore the agreement under 2703A, you must also ignore the redemption obligation. Because if you're ignoring the agreement, you don't ignore part of it, you must ignore all of it. There's nothing in 2703 which would suggest, well, you ignore part of it, but you respect other parts of it. It seemed to me it was an all or nothing deal. If the agreement failed under 2703A, it could not be given any tax effect or respect at all. So that was my thought. But the court in Connelly doesn't get into that. They mention 2703 once in passing. They don't get into the fact that in this case, the lower courts had held that 2703 required a disregard of the agreement. They're just mute about it. Obviously, they don't see it as having any significance. So before I wrap up, I wanted to just I set this up because Bob had asked me, Bob and I were talking, I think we were all on the phone if I recall correctly, and right after the case came down, and Bob said, well, gee, what about if these parties were unrelated? How would things shake out? I mean, here we have two brothers, so you could see this as a kind of, in the words of 2703, a device to transfer property to members of the decedent's family. You could argue about that, whether the brother falls into that category, but it certainly got that bit of a flavor to it. But what about if they were unrelated? And so here's my thought about that. This brings 2703 back to the table, okay? And it may give you some pause about what you want to do going forward in terms of drafting or in terms of reviewing pre-existing agreements. So take this case. Let's take Bob's case that Bob was hypothesizing for me. Let's say you had unrelated people. And so your intuition would be, well, if they're strangers, they're acting at arm's length, and therefore we don't have to worry about 2703. The value in the agreement should hold. That's, I think, the common instinct. That would certainly be my instinct in thinking about this. But let's say that in the agreement, an approach is adopted that says, let's make it very simple first, take a simple hypo. Let's assume the agreement says that the insurance proceeds should not be included in determining value. Okay, so you've got unrelated people and they have this agreement, they've got a formula, and it explicitly says, obviously I'm setting up a hypo that enables me to make this point, that explicitly says that the insurance proceeds should be disregarded, or there should be some discount for the insurance proceeds, or that essentially adopts the Blount approach. Okay, how will that shake out? Now, it seems to me, I think that's going to be problematic. I think that's not going to work. I think if I were the IRS, here's the argument I'd make. Look at the last prong of 2703B, right? It's on the screen. Its terms are comparable to similar arrangements entered into by persons in an arm's length transaction. If I were the IRS, I'd say, look at the Supreme Court decision in Connelly. They're telling us that as a matter of economics, right? As a matter of economics, this obligation should not result in a discount, that the insurance proceeds need to be taken into account. And there's this nonsense that Blount, forgive me for saying that, but calling it nonsense, but this nonsense that Blount had created is gone, okay? Well, it seems to me that in a case like this agreement is not gonna get into or fall within the scope of the 2703B safe harbor, because it's violating that third requirement. And so, or it's failing to satisfy that third requirement, or at least I think that's what the IRS would argue. And so I think you need to think about agreements going forward here about, have we addressed this in our agreement? Have we in some way done something in the agreement that calls for an outcome contrary to what the court contemplates in Connelly? If so, I think you're inviting some trouble if you're anticipating making that valuation stick despite 2703. So I think I think that's at least where I am. That's the state of my thinking at this point. We only had the case for 2 weeks and I'm still living with it, but that's where I am, and that's certainly a concern I have about the interaction of 2703 and the court's decision, even though, as I say, the court did not wrestle at all with 2703. All right, I think I'm gonna hand over the baton here to, or maybe we can get some conversation going, but I'm essentially done with setting up Connelly.
Hey, Marty, would you do me a favor and put up the examples, which we have? I can't remember which slides they're on, maybe 31, something like that. Yeah, here's an example. Let's say we have a company worth $1 million. We all agree it's worth $1 million. and it's owned 50-50 by two brothers. Actually, in Connelly, it was an 80-20 deal, but let's, for simplicity, assume 50-50, without any insurance payable to the company, and they agree that the estate of the first to die should be paid half of the value of the company without any discounts, or $500,000, because by premise, we know the company, there's no insurance coming in, there's nothing, it's worth $1 million. But if the company is to receive insurance of $1 million when the first brother dies, the company would be worth $2 million, and hence the deceased brother's estate should get $1 million, not $500,000. Now that just doesn't make any sense. The company was worth $1 million, and the deceased shareholders should get $500,000. Marty, go to the next one. Let's go to example 2. Suppose there is no insurance, but the company is obligated to buy out the company for half of its worth. That's what the agreement says. The company is worth $1 million, so half, without discounts, is worth $500,000. So if we treat the obligation to buy out the deceased brother as reducing the company's value, then the company is only worth $500,000, and the deceased brother's estate would receive $250,000. So the company's value drops by the $250,000 obligation to $750,000. Half of that is worth only $375,000, and so on. In turn, this produces a so-called interrelated calculation. The ultimate answer is that the deceased brother's estate would get only $333,000. But we know by premise that it's worth half. Remember, there's no insurance here. It's just that they've agreed the value of the company is worth $1 million, and the deceased brother gets half of that value, $500,000. And I think these two examples, reinforced by what Mitchell said, you do not take a redemption into account. You do, under the regulations, have to take into account non-operating assets, which would be the insurance. We know it's coming in, it's been received, and that would increase the value of the company. And, go to your next slide, if you would, Marty. And this will, Mitchell and I have discussed this many times. Why did the Supreme Court in Connelly ignore 2703? We may never know, but it seems that the reference, because it was unnecessary, because the obligation didn't affect value, as the foregoing examples demonstrate. So that's it. But Marty, I think the thing we need to do now is to decide, what should people do? Should you have a redemption agreement where the company is going to buy out the deceased shareholder, or are you going to have a cross purchase where the other shareholders buy out the deceased shareholder? And why don't you get into that a little bit, Marty?
So I have jotted down 5 points, that's being one of them, that we need to talk about what do practitioners do. There's been some talk about Connelly, certainly even before the Supreme Court. Now there's been talk about it. But the real bottom line is, what do we do and what do we tell people? So certainly there's pros and cons to a cross purchase versus a redemption. Redemption is where the entity buys back the interests, the economic interests of the deceased shareholder. A cross purchase, and let me illustrate it and also illustrate one of the problems with a cross purchase. Let's say Bob and I own a company 50-50. And instead of having the company buy $500,000, using, I think, Jonathan's example, on each of our lives, so that if one of us dies, it has $500,000 of insurance to buy us out. Bob buys a $500,000 policy on my life. I buy a $500,000 on his life. Well, one of the advantages to that is post-Connelly, I own the insurance on Bob's life. The company doesn't own it. That insurance is not included in the valuation of the company and not added back, if you will, to an estate tax value to the deceased shareholder. One of the negatives of a cross purchase compared to a redemption, if the company is buying the insurance policies, I may feel more secure that I know those premiums are being paid and funded from the company. With a cross purchase, you got to make sure that you address the practicalities to monitor the insurance payments. But there's another issue with a cross purchase. Bob, what if not just me and you own the company, but Professor Gans and Jonathan, you and me, all 4 of us own the company? What does that do to the number of policies we may need in a cross purchase?
Well, that's the problem. If the 4 of us owned a company together, we'd need 12 life insurance policies to make that work. If we were doing redemptions, we'd only need 4. So can you imagine a medical practice with 15 or 20 docs? I mean, you'd need full-time lawyers and CPAs just to manage the buy-sell process. Ridiculous.
Isn't that a good thing?
Not really. Not really. It gets too complex. And that's why the redemption agreements are very effective, especially for professional practices, because I die, you guys buy me out. The problem with Connelly, obviously, is it changes. It's possible. I think what happened in Connelly is Michael's estate received $3 million, but didn't have to include even more than that on its federal estate tax return.
Yeah. Yeah. Question. We need to emphasize, and this is important, there's another advantage to the cross purchase over the redemption, which sometimes sells use of a cross purchase if the number of policies, and we're going to come back to that. Jonathan, what does a cross purchase do for basis compared to a redemption?
Well, if you and I are in a business, Marty, and I die and you have however you fund it, but you buy my shares, well, all of a sudden, I've got more money, but it also means that your basis has gone up, because I don't know what your basis in your shares were before, but when you purchase my shares for whatever value, $500,000, $1 million, whatever it's called for, you're going to have a basis equal to what you paid. And that will not happen in a redemption agreement.
That's potentially a very significant factor.
It really can be, especially, Marty, as you pointed out a number of times. Today, with the high estate tax exemption, most of these smaller businesses, the owners aren't going to have much of an estate tax problem, but they're going to want basis. They want basis if they're an S corp, because then they can go ahead and use that for write-offs and stuff, or if they later sell the business, they want that. And that makes an awful lot of sense to think about gaining basis for income tax purposes. So that's something you've got to do. And there are ways to manage it. I mean, as Bob said, maybe you have to get 12 policies, but you could go ahead and get basically a separate entity, sometimes called an insurance LLC or an insurance partnership, where that entity would go ahead and buy the policy on each shareholder. So again, you're down to 4 policies rather than 12 policies, because that entity will receive it, even though it's buying it on behalf of all of the shareholders or partners or whatever the case may be. And I have done that, and I've never found it to be a problem. Similarly, as Marty points out, you're going to want to be sure that the premiums are paid. Well, one of the things you can do is to have the shareholders enter an agreement with the company and basically tell the company, when you make a distribution, you have to first make a distribution equal to the share of the premiums that particular shareholder or partner would owe if it were being paid directly by that person. So if the premiums are $200,000 a year and you have 4 partners that are all equal, well, each one has to put up $50,000, and that happens because he or she assigns a $50,000 interest in any distribution over to the company. And that way you can assure it's going to be paid. And that seems to me, and I've done things like that, a relatively simple way to go forward. And you get the basis bump, which I think in most circumstances is going to be kind of important.
Let's belabor that just a minute more. So Bob pointed out the practical implication of a cross purchase, which is with 4 of us being owners, we need a dozen policies. You've provided a potential solution, Jonathan, of an insurance partnership or LLC that owns the policies. So now back to 4. Does that insurance partnership or LLC need to have an existing business or other business purposes besides this? Is that an issue in the structuring of a successful insurance LLC?
Well, I don't think so. Mitchell, what do you think?
I don't think so. I'm sorry, Jonathan. Yeah, go ahead. You finish.
No, go ahead. Well, I know, for example, if you had a separate S corp, you can do an S corp even if there's no business purpose for it. You can certainly have a partnership even though there may be no direct business purpose for it other than to provide this mechanism to buy people out when they die. So I don't think that's a problem, Marty.
What happens? what happens, any of you, under a Connelly analysis to the insurance LLC? Let's say we go that route. Doesn't the same concepts in Connelly apply to the insurance LLC? So if Jonathan owns 25% of the insurance LLC, and there's a $5 million policy on each of our lives, isn't 1/4 of that value of the insurance LLC plus the $5 million included in the value of the LLC? So 1/4 of that's in Jonathan's estate?
Yeah, I think you're right, Marty. That's my sense of it. I was just going to add a couple of quick thoughts. So first of all, I'm aware of one PLR where they used an insurance LLC of the type Jonathan just described. Let me just give the citation in case people want to take a look at it. It's 2007 47002. There may be others, but that's the one I'm aware of. And they blessed it there, at least in terms of on the estate tax side. They also talk about an income tax issue. But so you might want to take a look at that if you're interested in the insurance LLC. In terms of the business purpose issue that Marty, you raised, I'm with Jonathan. I think it's okay. And if I recall the ruling correctly, we can take a look. I believe that either it's my recollection from the ruling or my own independent sense of things, that there may be sufficient business purpose because it's connected to the business of the underlying business. So I think that probably would suffice. I don't remember if the ruling explicitly makes that point, but that would certainly be, I think, the argument that could be made. So, that's the insurance LLC. Now, more specifically, in terms of your question, Marty, I do think my sense of it is that if the proceeds are payable to the LLC to do the redemption, I would think that you do have the Connelly problem, right? Now, in the 2007 ruling, the proceeds were going to be payable, I think, to the LLC, but then used to fund the cross purchase by the survivors. So I think the proceeds were going to go out to the surviving shareholder and then be used by the surviving shareholder to effectuate the cross purchase. And I think I think the answer to the question is probably somewhere along these lines. I think that if under the LLC agreement, the proceeds are going to be allocated to the surviving partner, right? So that the surviving partner can do the redemption, can do the cross purchase. Perhaps in that case, you don't have the Connelly problem. I don't know the answer, but that's an interesting question, right? Because the decedent's interest in the LLC doesn't, in that case, it seems to me, include the insurance proceeds because they're being, under the partnership agreement, allocated to some other member of the LLC. That's my sense.
Not sure, but I think it's something that practitioners need to think about when they're consulting with clients about what do you do post Connelly. Oh, let's do a cross purchase. That's fine. Bob, if I have a redemption agreement now, oh my, with Connelly, I don't like the result. Can I restructure that into an insurance LLC? Don't I have to make sure that I address the transfer for value rules in that restructure? Could that be an issue?
If you wanted to restructure that, you'd have to identify the policies were held in the S Corp. You'd buy those out by the LLC. You'd have to use the partner of the insured exception. Otherwise, under the transfer of value rules, when I die, Marty, you're going to have taxable income.
So there's some speed bumps we got to pay attention to in restructuring too.
Well, I think there are a number of ways to get around the transfer for value rule, including that if it's an original policy issued, then there was no transfer of the policy, so the exception to the 101A1 exclusion of gross income presumably would apply. And Bob also points out if it's a partner of yours, for example, you're not going to have a problem anyway. So I think there are many, many ways around it. The key is that you have to think about it in order to avoid the problem.
Yeah, and I always find the transfer for value rules, there's just some logical disconnects in them. I always go back and actually look at the statute to make sure that I got it right. So we've talked about already a couple of issues. It's not a simple matter to just use a cross purchase instead of the redemption. You have to think about it. Question, so if I have post Connelly a redemption arrangement, and now the value for estate purposes of the entity is higher than what I'm actually getting. Do I get a loss? Can I get a deduction for that loss on the estate or pass it through to the beneficiaries? Is there some kind of income tax benefit in all of this?
It would appear so. I mean, black letter law is 1014 A of the code says my basis is equal to fair market value at the time of my death. So you have the Supreme Court saying the value in this case was basically the value of included the insurance. So by definition, you're always going to have a loss. And Marty, you pointed out last week that almost every business not subject to estate tax should be embracing Connelly because of this potential loss. Now, you do get into an issue of whether you can use that loss and whether you run into any of the related party rules. You'd have to work through 267 to make sure you could free up that loss.
The other problem with taking the loss is this. I think the IRS would probably argue, assuming you get over the 267 related party rules, as Bob says, I think the IRS would argue that the sale is a part sale, part gift, right? I'm selling something for $1, it's worth $10 by definition, right? Because that's what the Supreme Court is saying here. And so I'm selling something, and I think it could be viewed as a part sale, part gift. Now, why is that important?
Gift to whom?
Well, if I'm selling something for $1 to the corporation,
the estate selling stock to the corporation,
right? For $1, and it's worth 10, right? So you're making the argument, I think, would be you're making a gift either to the corporation, or for gift tax purposes, we would treat it as a gift to the shareholders. You know, we pierce the veil under the 2511 regs. But putting that aside, putting aside the question of who exactly is the donee, I think that there's an argument here. You're selling for less than value, right? For less than tax value. And so therefore, it could be viewed, I think the IRS would say, as a part sale, part gift. And in the regs under 1001, 1001-1, they say that in the case of a part sale, part gift, no loss is permitted. So I think that the 1001 reg would be a very powerful weapon, I think, to the service in a case like this, assuming they could make my characterization stick, that this is a part sale, part gift. But I do think it's got that flavor to it for sure. And I think that reg would be a critical place to think about this transaction, this law question.
Might the result not depend on the relationship of the remaining shareholders?
Maybe, possibly, I don't know. You know, can I do a part sale, part gift with someone who's not related to me? Yes. So I think surely if they're related, the IRS's part sale, part gift argument is stronger. If they're unrelated, perhaps it's not as strong. But I do think you have that problem. You're selling something for less than its value, and you know, the reg is designed to say, hey, you're selling something for less than its value. That in and of itself is suspect, and we're not going to permit the loss deduction. So I think anybody who's you know, arguing for this loss deduction has to deal with the 101 reg and explain why they don't think it's a part sale, part gift. I was going to come back and say something unrelated for a moment. I don't want to steer the conversation, but let me just say this. I thought there was something interesting at the end of the court's decision. I think it was like the last paragraph. The estate was making this argument. You know, we could have gotten to this result had we done a cross purchase. So why can't you give it to us? You know, I mean, the two approaches, cross purchase or redemption, are essentially equivalent in substance, kind of a substance over form argument, right? And why don't you treat us in a way that would be the way you would have treated us had we done the cross purchase? And the court gives that argument the back of its hand. So I think it's kind of interesting, because I think what the court is saying there, it doesn't flesh it out all the way in these terms, but I think the court is saying, you know, substance over form is an argument that's uniquely available as a general matter, with some exceptions, but as a general matter to the IRS, not to the taxpayer. If you screw up the form, don't come to court and ask us to treat you as if you had done it the right way. You know, so I thought that was an interesting aspect of the decision.
So let me pose another question to all of you. And I think one of the key themes that's coming through here is the more we talk about this, the more complexity and more layers that seem to come out of this. It's not a simple result in dealing with it. So let's say I have an agreement with Bob. Bob and I are partners, and I have an agreement with Bob to buy out. But we don't set it based on a valuation or a formula. We set it at fair market value, which is determined by estate tax purposes, right? Doesn't
Marty,
that...
Marty, are you saying that your agreement with Bob says that when one of you dies, the other will buy out the deceased owner at fair market value as finally determined for estate tax purposes?
Well, maybe, yes, something like that.
Okay.
What's the implication of that? Because we may have had a business that we thought was worth 10 million and our half was each worth 5, but now with Connelly, the 5 million of insurance is included in the value of the business. So isn't that going to make the business value 7.5 million? So by using that wording, does that now require me to pay Bob's estate 7.5 instead of 5? Might the wording in the buyout agreement, depending how it's done, impact the economics of what has to be paid?
Absolutely,
Well,
Marty.
yeah, I think that's, correct. It's how you define it. And if under your meaning of fair market value, it would include the life insurance proceeds, yes, then I think you have a higher value and half would be worth that much more.
So I think that's a real important point for practitioners to consider, because everyone needs to go back and reread every redemption agreement, because if the parties thought they were paying out a figure that was half the value of the business based on a formula that an appraisal firm, constructed that was set to be arm's length and fair, now the insurance is being added to it. It's not just that you have an estate tax potential whipsaw, but you may have more that has to be paid out than what you anticipated. Is that comments, thought?
I agree with you, Marty. I think that's a very important point. I think you had made it to me privately, and I thought it was, or maybe I read it in what you wrote with Jonathan and Bob, but I think it's a very important insight. And here's why. I think because most people, most lay people certainly, and maybe lawyers as well, kind of think of the insurance proceeds as a freebie. We don't think of it as being added into the pot, right? It's the money comes in as a freebie and it's used to pay off whatever the value of the decedent's interest was. We don't think that that's going to wind up enhancing the value, the valuation. And I think that's a common sense kind of a thing, an intuitive approach. And I think obviously Connelly is contrary to that intuition and creates the potential for this kind of problem. I think it's a good point.
So I think we have to look at not only how we may restructure agreements, but if an agreement is even going to stay the same, we have to look at the verbiage, the wording in the language, and find out from the clients, what is it that you anticipate? It's one thing if you get an estate tax issue, but it's also another if you're going to have to pay out more money.
Well, Marty, I think that the deal here is that you don't want the insurance to be part of what you have to pay estate tax on. And each of us on this call and virtually everybody who is listening knows that there are ways to do that. You create a so-called crummy trust where you keep it out of the estate of the insured entirely, and you structured it so you get the benefit of the annual exclusion. And perhaps that's something that really needs to be considered, because if we're in agreement, the business is worth $1 million. So I want to have 500,000 for my half, but we want to fund that with life insurance. We've got to make sure that the $500,000 of insurance doesn't bump up the value, and it's otherwise not includable in my estate. And so you've got to, set it up that way, which again, if you're careful in your structure, you can do.
There's also, I was just going to add, Marty, that, and Jonathan, there's also I think, this is an issue you and I, Jonathan, have been through over the years, a tax apportionment, kind of a subtle tax apportionment issue, isn't there? Right?
Yes. Yes.
I mean, now that we have this extra estate tax on this extra value that the Supreme Court has created for us, who actually is going to bear the burden of the tax on that extra value, right? And it's going to depend on, what you provide in your instrument in terms of tax apportionment. Is it the other partner or shareholder? Is it your residuary if that's where you're imposing the estate tax? I mean, I think there's an interesting tax apportionment question that needs to be thought through here.
How can you make the other partner bear the tax cost if they're not a beneficiary under your will?
Well, it's merely state apportionment, Marty. I mean, if I die and you get life insurance, which is subject to estate tax at my death, and the rules are that you have to pay your proportionate share of what that insurance generated. You'd have to pay it. Now,
I'm confused, and maybe some of the listeners are too. If Bob and I own a business and it's worth $1 million and we have a $500,000 redemption, that insurance adds to the value of my estate's interest in the business. It's not to Bob.
Take a simple, I'm sorry, Marty, I'm just trying to help. So take a simple hypo first, then do your hypo, because I think this might be helpful. So let's say, for example, you and Bob are partners, as you say, or co-shareholders, and under your agreement, Bob, at your death, is going to be able to buy it for $1, a nominal sum. And we know that the value of the business is significantly greater than that, right? So in effect, Bob has become one of your legatees, right? And under the apportionment statutes, assuming you don't have a contrary provision in your instrument, in your will, right? Under the apportionment statutes, Bob, depending on what state you're in, I suppose, we have some authority in New York on this, Bob could be treated as a legatee for purposes of tax apportionment and be required to make some contribution to the estate tax with respect to what's in substance a bequest that you've made to him. You see it?
That's true. In fact, I've long regarded, and I've written about this, that the tax apportionment provision in your will is perhaps the most dangerous one of all. And when I began practicing, all lawyers, and I mean all lawyers, had the same. It said that all taxes due by reason of my death shall be paid out of my residuary estate without apportionment. And that meant that if you had an asset outside of the estate and it generated estate tax, as we're now thinking would happen in a Connelly situation, even though the insurance proceeds are received by the entity, then you're going to have a mismatch of liability for the tax and who actually gets the benefit of the insurance proceeds. I urge the most narrow kind of tax apportionment clause. Only property that's passing under that instrument should create the burden of tax and have the balance of that particular pot pay the tax. Very, very important. And there are circumstances, for example, where you do have a redemption agreement. It's not going to be basically reduce the value, as in Connelly. Who pays that additional tax on the insurance proceeds?
So this is getting even simpler the more we talk. So now we have to go through the cross purchase, the potential for a Connelly application to the insurance LLC. We have to look at the language and the redemption to see if there's a mismatch between what the partners intend to be paid and what economically may now be paid because of an inappropriate use of language. I have to go through their wills and look at their tax apportionment clause, right? So this is getting more fun as we go through it, right?
Well, that's right, Marty. And I suppose that even though many of the state apportionment laws apportion taxes based upon who gets the benefit at death, it may be that someone who receives a benefit from a redemption, they buy it cheaply, but there's an estate tax paid on the greater value, can argue, hey, you can't apportion to me because I'm really a creditor. I'm not a legatee. And there is some law in New York to support that notion.
Well, I know what everyone's going to be talking about at their July 4th barbecues. I mean, no doubt it's going to be this. I have two more quick points that I think we should just touch on in terms of practical implications. One of you mentioned it a minute ago, but the vast majority of estates are not subject to estate tax, even after the reduction in 2026. So what do you tell a client if you know they're not going to be subject to estate tax? What's different about that? Why not just do a redemption and not go through all these complexities?
As long as we understand the economics, as long as we don't end up in a situation where we have to overpay for that. So if the business is worth $1 million and I die and I own 40%, I should only get $400,000, Marty. That'll be the key, just having the drafting right. So the insurance is kind of like extra.
And a final question, unless you have other thoughts in terms of practical application. One of the things, and this has been a constant in so many cases, we had it with Smaldino at the end of, I think, 2021. We had it in a positive way in the Levine split dollar economic benefit insurance case. We had it in the Sorensen firehouse sub case and others. The IRS has often attacked plans, and in one positive one, Levine kind of won because of the adherence to formality. But Smaldino, Sorensen, Connelly, all these taxpayers ignored the formalities of their own plan. How much relevance do you think there is to that here? Do you think that had they adhered to the terms of their document, maybe it wouldn't even have gone this far? Any thoughts or comments? Because I think the bottom line is we got to make sure everyone's adhering to everything that they set up in their plans, because it never works well when you don't. But just any comments or thoughts about that?
Marty, I think that's excellent, because I've often been involved with people who had a deal and they never followed through on the valuation. I think it's more common than not that people have a bot every year they're supposed to set a new value and they just don't do it.
Never.
And you know, one of the things is to tell your clients that if we're going to go here, I am going to make you come in every year and come up with a value. Or we're going to hire an appraiser, and every year that appraiser is going to come in and a value, and you've got 30 days to complain about it. Otherwise, that's what's going to be paid. And that might be more businesslike and really get respect and be one of the things that you could say, see, strangers do these kind of things.
Mitchell, any thoughts? Do you think they may have avoided some of this if they'd actually adhered to the terms of the agreement? Maybe the IRS wouldn't have pushed it so far?
You know, I don't know. That's a good speculation. Possible. You know, it's certainly possible. As a matter of law, in terms of the way the Supreme Court conceptualized it, I don't think that was at issue. I don't think bad planning accounts for the outcome in the case. But
no, I agree fully. But I wonder if on audit it would have gone this far if they had not been so bad.
Yeah, I mean, you know, what comes to my mind is all the family limited partnership cases in 2036, where people use the partnership as a family pot, you know, and they don't respect the partnership as an entity. They just take money out as they need it. And, you know, obviously those are problematic cases, and those are the cases the IRS loves to jump on. But yeah, obviously it always pays to dot the I's and cross the T's, but it will not always get you across the finish line.
Correct. Well said. Gentlemen, this has certainly been fascinating. I didn't anticipate some of the areas that we ended up getting into. I think none of us actually did, and that just shows what comes out of the complexity of the Connelly case. Why don't we just go in order? Mitchell, any final comments, recommendations, thoughts?
Well, I think, just summing up, I do think I'm still interested in the 2703 piece that hasn't been resolved. And I'm curious to see how things are going to shake out in terms of the hypothetical purchaser framework. Is it going to be impacted by what I think the court inadvertently did? You know, I think it stepped into a problem with the way in which it formulated the test and was internally inconsistent. So I'll be curious to see how that shakes out.
Jonathan?
Well, Marty, I found this very, very interesting, and it goes to show that people really need to pay attention to their agreement, and they need to keep it up to date. And I think the lawyers can do a lot, and the accountants can do a lot for their clients by making sure that they do pay attention to the agreement. And in fact, if you have two owners of a business and they don't have an agreement, the lawyer or the accountant ought to bring it to their attention. What are you going to do if one of you dies? Do you really want, you know, her husband or his wife or boyfriend or girlfriend or those horrible children that he has to become your partner, so to speak?
Bob, before I give it to you, let me just amplify something Jonathan said. I even add the wealth advisor to that list and the insurance consultant, because clients will often go to their wealth advisor 4 times a year and only their lawyer every 3 to 5 years. Wealth advisors are pretty adept now at always asking clients, how old is your will? You don't even have a will? They need to add Connelly to their checklist. If a client has a closely held business, the wealth advisors need to tweak the clients and say, get over to your attorney and accountant and get this stuff addressed. So all the advisory team needs to jump in, because clients are going to be oblivious to this, and it could have, as I think is clear from our conversation, lots of potentially costly and unexpected ramifications. Bob, any final comments, thoughts, recommendations? What are you going to tell your clients?
Cross-purchase agreements when manageable. So if it's just 2 or 3 people, we'll go with a cross-purchase agreement.
And if not, why not an insurance LLC?
That's where I'll have to go. I'm just curious to see what happens in the next 6 months. There are hundreds of thousands, if not a million, small businesses in the United States, and we need just a path forward from where we are now. And the problem with Connelly is, simply put, more was included in Michael's estate than he received. And that means if you have residual apportionment, his children paid the tax on what went in directly to his brother Thomas. So that's something nobody wanted that result.
And no one's going to be happy with that result other than the brother.
Of course. Now, to Mitchell's point, though, you would, if you had that, you'd explore whether someplace under, I think, 2207, there was some right of recovery against that property. And that would be something you'd have to explore.
Yeah, but the problem, Bob, is that people often have wills, and the wills have some sort of tax apportionment in it. Or you've got to look to state law, which could be a little different. Florida's tax apportionment statute, as I recall, is somewhat different than New York's is, which is somewhat different from probably every other state. So, you want to have something in your instruments to deal with apportionment, but just make sure that you're not going to wind up having the family pay estate tax on something that's going to someone else.
That's exactly.
And where you have a buyout that's going to be less than the estate tax value. And so you're going to have the family pay the estate tax. And again, even if your instrument doesn't say it, because there's a case in New York which says that the person who has the right to buy out is actually a creditor, and you can't apportion estate taxes against a creditor. So that's something that really needs to be thought through. I urge everybody to do it. Not enough thought is really given to that issue. It's an exceptionally important one.
I think, when we couple what I thought this was going to be complicated before we got started. It's much, much more complex with much more nuance and many more layers than I had imagined before starting this program. And you couple this with the Corporate Transparency Act, planning pre-2026, the FTC's ban on non-competes. Our closely held business clients really have a long list of complex issues they have to address. And I wish all of us luck in dealing with it. Thank you for joining us, and thank you for speaking, Mitch and Jonathan and Bob. It was enlightening to me. I hope it was enlightening to the audience as well. Thank you, everybody.
Thanks, Marty. Thanks, everyone.